Hi, everybody. Welcome back to 10 Minutes with Griffin. I'm your host, Griffin Bridgers. This is going to be a two-part episode that I'm going to break up into two parts with the same set of slides between today and tomorrow. This is really kind of me laying the groundwork for a video I hope to produce in the future more comprehensively, known as Guardianship for Minors 101. So this is just kind of my rough run at this, but it's also helpful, if you're an advisor or an attorney who deals with parents of minor children, or even if you're a client who has minor children and this is a planning gap that you need to address. What I hope to do is give a little bit of certainty to the process that may have universal application in some cases. And I also hope to expose what a lot of people aren't aware of, that this is becoming a very opportunistic area of planning where a lot of people out there can take advantage of you if you're a young parent with this planning need. Now, as always, this presentation is not intended to substitute for legal or tax advice and is provided for educational purposes only. So for today's presentation, we're going to focus mainly on the problem and maybe get into the solution, but our episode tomorrow, episode 145, will be more solution-based. Now, up front, the conundrum here is two parts. One, if something happens to one or both parents during life in a situation where maybe their minor children can no longer be cared for by both of them, the court could intervene and require the appointment of a guardian, or the state could intervene. Now, parents loathe thinking about that. And if that's you, I get it. I understand. It's terrible to think about that possibility. But ignoring it doesn't make the problem go away. And as we're going to find out, it's pretty easy to actually solve this problem. There's simple documents you can get in place. And the problem is that there's a lot of estate planners out there who look at you needing to implement a perfect plan as opposed to just addressing this planning gap in a piecemeal fashion. And what those estate planners will do will prey on this fear to sell you an overly complicated, overly expensive estate plan in the name of protecting your minor children, but with a lot of bloat that may just not be required at the end of the day. So, this series of presentations is going to be about how you create control and certainty in the process. How do you appoint guardians? How do you make your wishes known as to who the guardians of your minor children might be? And how can this be done quickly and easily without a lot of headaches, without needing to get a perfect estate plan in place and go somewhere and pay thousands of dollars to address this planning gap that is important, but also very scary to think about. Now, a lot of the principles we're going to talk about in this series are going to be, commonly applicable among all 50 states, but some states may not apply all of these principles in the same way. So it's important to check with an attorney in your state and maybe an attorney in the state of your nominated or appointed guardian to address where there might be conflicts between state laws that could arise. Now, the big question on everybody's mind is, what if I'm overblowing this? What if I do nothing? Is it really that bad? Do I really need to care about this? Especially if there's a remote chance that something happens to both my spouse and I, or a remote chance that my child is left without a parent or guardian. And I think it's important to note that the court is going to intervene regardless, especially in a situation where both parents are deceased. But by controlling the process with documents that you create during life, you reduce the uncertainty and create a more seamless transition. Now, a lot of this is going to depend on the state that you're in. In some states, court involvement is going to be terrible. And in other states, it may not be as big of a deal. But I think the important point is that if nothing is done, then in most cases, the state may take custody of a child if no family member is willing to step forward. So really what this is designed to do is to force a family member to step forward through an advanced conversation and eliminate the ability of other family members to step forward who you may not want to have guardianship, and also create a more seamless transition between whatever event triggers guardianship and then finalizing that guardianship in the hands of whoever you wish to serve in that role. Because ultimately, greater court involvement is just going to mean greater emotional trauma to an already traumatized child. And it could mean greater expense to you or to your estate or to your family members. And obviously, the well being of the child outweighs the financial issues, but we will touch on the financial component of this in tomorrow's episode. Now, a lot of you might also be saying, well, I told my sister I want her to be guardian. Isn't this good enough? Well, plainly, the answer is no, it's not. You have to do something in writing. So I'm sorry if that's you. You can't just rely on what you've told family members, because they could end up fighting at the end of the day. Ultimately, to expressly make your wishes known as to guardians, it has to be in a writing in an approved form, which we'll look at later on. Now, what you say during life, even if the intent is good, is often the least reliable form of evidence for your wishes, in this area or any situation where you might be deceased, because of a principle of evidence called the dead man statute. Now, it's called the dead man statute not out of gender insensitivity, but because that's what it's been called. So by calling it that, I don't mean to create any sort of insensitivity issue. I only call that out to just say what the statute and evidence principle is called in most states. But what that would do is it would cause your sister's testimony as to what you said to be ignored. If your sister stepped into court and said you'd named her as guardian, then the court considers her an interested person. She's interested in the outcome by claiming to be guardian. And what the dead man statute does is it says that anything that's like hearsay can be ignored if it's brought up by a person who has an interest in the outcome or the conflict. So even though the intention is good that your sister wants to be guardian, what you tell her can be ignored here. So, in order to name a guardian, before you get to it, you need to give serious thought to your choice. There's some homework to do, and ultimately, this is a balancing act. Now, perfect is the enemy of good. This is something where you need to take some action and get something down because it's easy to change at a later date, as we'll see. So this isn't just an exercise, and on the other hand, to fill in a blank in an estate planning form. There's some things to think about. So it's important to strike a balance between doing this too quickly and then doing nothing and putting this off forever because you can never come up with a perfect solution and you're worried about paying to change it at a later date. And this is where a lot of people could prey on you in terms of planners and advisors. You can't pay somebody to do this homework for you, and ultimately that's the hook that a lot of people could sink in. And there's a number of issues that come into play that are often overlooked. For one, married couples make good guardians. You might want your child to have that stability of a two-guardian household, much like they might have had in your house or might not have had. But it's important to note that married couples can divorce. So what happens if they divorce? What happens to your child? Do they become part of a custody battle? And is the guardian who gets custody not necessarily the person who you would have wanted to have custody? It's important to shore that up in any sort of document naming a guardian. And in the worst case, what you could do is either look at naming an individual instead of the married couple, or you could just say that if they ever divorce, their guardianship is terminated and the child would then go to another guardian. Now, it's also important to note that guardians may live out of state. Now, there's a lot of emotional decisions you need to make about whether you want your child's lives to be uprooted, and that may not be as big of a concern if the guardian out of state is a really good fit. But you have to balance that with maybe a less desirable guardian who may be able to keep your child in their own school system, in their own neighborhood, around their same friends. That's something I can't give you the answer for, but what I can tell you is that if you do have guardians who might live out of state, you do need to shore that up, because, as I mentioned earlier, there can be interstate conflicts of laws. What's effective in your home state may not be effective in the state where your guardians live. Now, finally, it's important to note that your nomination or appointment of guardian may vary in terms of the weight that the court gives it in some states. Now, first off, children who have reached a certain age, usually age 12 to 14 at the top of the bell curve, have the ability to consent to or reject your guardian appointment. And if they do, that could override your wishes. Then it's also important to note that between your state or maybe the state where a guardian might live, some states are guardian appointment states where you can appoint a guardian and the court is generally bound by your appointment outside of just egregious circumstances, while other states are only nomination states where the court can consider your nomination, but they aren't necessarily bound by it. They don't have to give it as much weight as a court in a guardian appointment state might be. So you need to know which state you're dealing with, both in terms of your own home state and the state where your guardians might live if they live out of state. And in a situation where you're in a nomination state, this could also arise in an appointment state, the court can override your wishes by considering a child's best interest. So, while we're creating certainty here, that certainty may not be as strong as you desire, so if you anticipate conflicts with family members or in-laws, those can come into play, and it might be helpful to create instructions to the court as well as to your wishes. But we'll touch on that in tomorrow's episode 145. So, that was a preview of the slides to come, but for the time being, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. Join us again for episode 145, where I'll wrap up this discussion. And as always, thank you for listening to this episode of 10 Minutes with Griffin, and I look forward to seeing you in the next one.